Travis Wayne Goodsell. It's very interesting that the Church of Jesus Christ of Latter-day Saints' lawyers in my civil case against them, 219 CV 00711. They've not sent me my waiver of summons portion. They're supposed to send that to me. And then they're supposed to send me a copy of their response with their motion to dismiss that they sent on the 10th. We're going on almost a week now, and they've not served me with the response. They're supposed to do that because here I am looking at step 5 for if you've been sued in the federal courts with a civil case. And this is part of the disturbing part, because it's not something that they can do a waiver of summons. They're a corporation. They don't get that option. They have to serve me. They've submitted it to the courts already. It's in the judge's hands. And I'm supposed to have 14 days to respond, which means they're purposely withholding so that I have less time to respond. I, however, already emailed the judges on this and informed them that I knew about it by looking at the docket and pointed out their bad faith in the matter. But for them, a professional lawyer firm representing a big corporation in the trillions, guys, for them to behave unprofessionally is quite a criminal action in and of itself. And so let me read over step 5 for you about giving the plaintiff a copy of your response, the defendant's response. And it's speaking as the person is supposed to be the defendant. So understand when it says you must, and it's referring to the church's lawyers. You must generally give the other side a copy of any document you file with the court. Now, in my particular case, I was approved for informa pauperis. Judge First was required by federal law to grant or order the U.S. Marshals to process serve. She refused to do that. As a result, I did the waiver of summons finally, and but it doesn't work on for the defense in this particular case. If the other side has an attorney, you must give the documents to the attorney instead of the other party. I don't have an attorney, and it's known that I don't have an attorney in the complaint, and my address is correct. They can find me, but they're supposed to give me that motion to dismiss. They can't just say, oh, well, it's on the docket, you'll find it, and you can pay the money to download it. They can't do that. So giving documents to the other side is called serving or service. After the initial complaint, all other documents filed with the court will probably be served by putting a copy in the mail, delivering a copy by hand delivery, or some other method allowed by the court's rules. There's certified mail they could have done. They could have had a service processor They're lawyers. They can handle it. But some other method allowed by the court's rules. We haven't gotten that far yet because the judge hasn't officially declared that I'm allowed to serve. And so for me, my response would include another waiver of summons, is what it would be. Unless the judge says, all right, fine, you can have the marshals deliver it. But she's ending her service at the end of this month. And so that's why this is all a big scandal, guys. This is not following due process. This is not following the rules of the federal courts for civil procedure. And so the church lawyers, like I said, they're green. They're little kids. And they failed to do their job, which is a simple job. Everybody should know how to do it. You send a motion to the court. You send the motion to the plaintiff who's suing you. They know how to do it. They've done it a billion times to billions of other people who have been suing. And I posted the video the other day about abuse in Mormonism. It's a website where if you've been sexually abused by someone in the church, doesn't matter who, if it's the church, somebody in the church, you get to sue. And they have lawyers that will help you in that process. So, yeah, the church's lawyers know all this. And when you serve a motion to dismiss, rather than some other type of motion that defense attorneys would respond with, they're saying that I don't have enough evidence. I haven't gotten that far yet, but I have proof, because they know damn well what they did. I've got the evidence. And when I get to the point where I present to the court my list of evidence to be submitted, it will include all the evidence. And so their claims to no evidence doesn't hold any water. And it's not the wrong jurisdiction. They are the church's lawyers. They responded. So unless the church dropped them right as I filed and got a whole new legal firm, that's not the case though, because Swenson reported for the church in regards to a reply with $100 billion in tithing. I believe it was him who responded. So, oops. Not the case. So, let's see. Because they're supposed to send the court the certificate of service form, which is what I would have had to have done had the judge said, yes, the marshals will deliver it, and then I submit the forms for the marshals then take it and do the serving process. And so, because the judge refused to do that portion, I then followed the waiver of summons, and that bypasses that for me. But for them, they're supposed to provide the court with certificate of service, and they haven't done that. And we're going on a week now with just leaving me a week to respond. Like I said, I already notified the judges. And so, yeah, they're supposed to be receiving, let's see, it says tip. If you filed a motion, the court clerk is going to give you a hearing date. Make sure the copy of the motion you serve to the other side has the date and time of the hearing on it. This just is unacceptable for the church's lawyers to make this massive of an error. Massive. Otherwise, they won't know when the hearing is scheduled. Oh, gee, that's what we want. We don't want them to show up. And so, again, this is unprecedented. Nobody wants to follow the rules that they went to school for. They passed the bar. They got the licenses. They became judges for the judges involved in this. They became lawyers for the church because they're Mormon and they want to protect and serve the church against the evils of the world. And they failed. They all failed. The judges, the lawyers. It's like there is no rules. There is no laws. They just make it up as they go. I don't want to deal with this. I'm not going to respond. I'm not going to give the plaintiff a copy. And granted, we're in coronavirus time, but still, they are needing to follow a process here. It's just unfathomable. The evil, the corruption, and the ignorance. You know, yes, Spaceballs was hilarious because Dark Helmet said that evil always wins because good is dumb. Something like that. But I'm sorry, that's just not the case. Evil is dumb. Because if they were smart, they wouldn't be evil. Because once you are evil, everybody is after you. Because you've been lying, cheating, stealing, murdering, and they don't like that. And so they're coming for you if you're evil. That's why evil is dumb. You gotta be good. And yes, people may take advantage of that, but guess what? The good now recognize you as evil, and they come after you. That's why evil is dumb. That's why the church is dumb. That's why I'm suing the church. It's not complicated. If the church just left me alone, they didn't have to accept my Paleo-Hebrew decipherment. They didn't have to accept my Egyptian petroglyph decipherment. They didn't have to accept my discovery that the biblical narrative stories were taken from the Egyptian petroglyphs at the various levels of translation. And I've gone over this with you. They didn't have to do any of that. But they didn't have to come after me, blacklist me, have me disappeared, threaten my life, try to murder me. Evil is dumb. That's the moral of the story, boys and girls. Got more. In Gaddy versus COP, the Judge First, or actually it was Plead, I think, allowed it to be filed electronically because Gaddy had paid the $400 filing fee. In my case, it was in form of papyrus, so I had to wait for Judge First to approve the service of process by the U.S. Marshals. That's why there's a difference. And so there is no order for how to proceed in the future with service. And so it looks like the church's lawyers filed the motion to dismiss and memorandum in support with the clerk directly, rather than through an email process, online process. Not sure. It just says motion to dismiss and memorandum in support filed by the defendant. And it was Swenson who was the one who filed. It's got his parentheses and name attached to it. But as I'm looking over the Legal Information Institute from Cornell Law School, which is taken from the federal filings, they just repeat it. It's talking about papers after the complaint. Any paper after the complaint, which would be their motion for dismissal, that is required to be served, must be filed no later than a reasonable time after service. And they missed the deadline, so it's not a reasonable time. And so we got coronavirus for 2 years, so who knows how it's going to work. But that's what I would normally respond in my reply to their motion to dismiss, is that they did not file within a reasonable time frame after service, as they were late and are subject to default. When a paper that is required to be served is served by other means. Let's see. No certificate of service is required when a paper is served by filing it with the court's electronic file system. And that has not been the process. It's not listed like it is with Gaddy VCOP. And I think that's where he went wrong, is that he's assuming I've paid my fee like Gaddy or Kay Birmingham did on behalf of Gaddy. And I think that's how he slipped up. If the paper is filed, a certificate of service must be filed with it, or within a reasonable time after service. So he must have filed electronically when I'm not yet approved for service. He screwed up royally. My God. Because there it is in, let's see, 1BI, which comes from, let's see, 5? Yeah, Rule 5A, service, when required, lowercase a, and then, where was it? Oops. Oh, B, service, how made. So 5, lowercase b, 2, wait a minute, where is it? I lost it. Where is it? Filings. Oh, it's D. Okay, so 5, lowercase d, filing. 1, required filings, certificate of service. A is the papers after the complaint. And then B is certificate of service, requiring a certificate of service to be filed when he submitted his motion to the court. And he didn't do that because I didn't get served, which means he did it electronically which I have not been notified of the electronic filing system, nor have I been involved in setting up an account for that purpose. Now, if they're assuming that I'm supposed to know, they didn't, because I went through this whole schmeal where I didn't get the service of process for the U.S. Marshals. She didn't give it, and as a result, I didn't get served with the motion to dismiss. This is awesome. I think they didn't serve me, and so I'm going to immediately contact the courts by email again, informing them that I have not been served, to remind them again that I think they're thinking that they could do it electronically when I've not been allowed to do it electronically. So we'll have to see what goes on here. This could be game, set, match. I mean, granted, it's an oversight, and the judge can simply say, "Hey, you need to serve the plaintiff," but they were already late, and I'll remind the judge of that it was not filed in a reasonable time, again, reminding them of that. But I can now put the actual laws for that. But it's supposed to be an emotion, but again, I didn't get served, and we're in a coronavirus where the court's shut down. And I don't know if Judge First is even going to bother to respond to anything. She's trunky, as missionaries in my mission field in New York, back when I was a 19-year-old kid, called it. My first 3 missionary companions were on their final month. So here I am, a greenie, out in the mission field, and I send home the first 3 missionaries. So yeah, and then helped to be in the pleasure palace as well. So wow, this is huge. Holy crap. How did they mess up? Judge First, that's how they messed up. It's because she messed up. Alright, I'll add the email I'm sending to First and Waddups, Judges First and Waddups, so that you'll have up-to-date information as I'm giving it. And so, like I said, if I notice anything before I send it, I'll keep adding to the video. But here's what I have so far. I had to put my name, full name, and the case number, 219 CB 00711. As of today, 16 April 2020, the plaintiff has not been served the defense counsel's motion to dismiss filed with the court 10 April 2020. As the plaintiff must not be the defendant's typical plaintiff, as pro se and approved for informa pauperis, the defense counsel appears to have filed electronically, which would explain why the plaintiff has not been served the motion to dismiss in accordance with Rule 5dB, service of our certificate of service. As Judge First has refused to order service of process from the beginning, forcing the plaintiff to file a waiver of summons instead, the plaintiff has not been set up for electronic service and would be forced to pay PACE Monitor to acquire all future documents in the case. As I remind the judges, the Utah Federal District Court is on general order, preventing the plaintiff from filing with the clerk's office. I also remind the judges that the defense counsel did not respond to the plaintiff's complaint in a reasonable time, as they were informed the filing deadline was 30th of March 2020. Yet they did not file until 10 April 2020, and in so doing failed to serve the plaintiff. Rule 5DBI. Nevertheless, my request in the previous email still stands. This is not complicated. It really isn't. I've done this before, and because I did it before, I was then disappeared after failing to punish me adequately. Judges Benson and Kimball were the tag team on that lawsuit back in 2006, where I was told that it was with prejudice. I could not refile. Yes, the church was involved in that one, along with the state of Utah and others that I was informed to add, but that's how they dismissed it. Because I wasn't supposed to add them, as they told me I was supposed to add them. But anyway, so there's your update. I can't believe they messed this up. The whole thing is just wrong from the get-go. Unbelievable. And Judge First is leaving, and they'll most likely start all over again whenever coronavirus ends. But so furious. I told her I expect the government to be shut down and that it's too late. She nevertheless, because I had pointed out that the church was paying the person who had me disappeared, she gave me an opportunity to refile. But I told her I don't expect it, and I put it in the lawsuit as well. I don't expect the government to be operational. I was right, wasn't I? Because Trump had other plans than shutting down the government again like he did last year.